Hi, everyone, and welcome to the Life Hack stage at MomFest Digital 2020. I'd like to introduce you to our first presenter and special speaker today, Erin Burry from Willful. I will see you guys later in the day. Erin, up to you. Over to you.
Wonderful. It still says backstage on mine. Is that okay?
Yeah, you're good. You're live now.
Amazing. Okay, then everyone's hearing me ask about it. Hi, everybody. I'm really excited to be here today at MomFest. I have to confess, I am not a mom myself yet, but I am really excited to be here talking about something that I think is super important. It's not the sexiest topic on the agenda. I'm not a lactation consultant. I don't have, the really fun stuff to talk about, but I know that as new parents or expecting parents, you are probably thinking about all of the financial stuff that you need to get in order. So today I'm here to talk to you about the very exciting world of wills and estate planning, which may also be a little bit top of mind because of COVID. So I'm going to share my screen. I can't see the chat at the same time, but I will definitely kind of pop in and see if there's questions as we go. And if you have questions, please pop them into the chat. I'd love to answer them. You can also find me on Hop In later and ask me any questions, and I'm gonna get started. So I have about 30 minutes and lots to get through. So I appreciate you coming and listening today. Hopefully you're in your pajamas and you can just sit back and relax and learn a little bit more about wills and families in 2020. So first, I'll start with the Willful story. I think it's always great, especially right now, to be supporting women-led small businesses, and that is very much Willful. I'm proud to say that 75% of our executive team are female, and we have a team of over 50% women. So go us. And really the idea for Willful came from my husband, Kevin, who is a tradesperson. His background, he is not an estate lawyer. He is not a seasoned business person, but like most great business ideas, he came across a personal problem that led him to want to solve it through a business. His uncle passed away unexpectedly a few years ago, and he had a will, but he had never discussed all of the things outside of a will, like burial wishes and funeral planning. And so his family was really just scrambling to figure out what Uncle Dave would have wanted and to kind of do right by his legacy. And we were in our early 30s at the time, and we were using tools like Wealthsimple and all of these other apps and digital tools to manage our financial life. And we thought to ourselves, why is estate planning being done the same way that it was 30, 40 years ago, where you're going to a lawyer's office, you're making appointments, it's mostly paper-based, and it's expensive and inconvenient. So we set out to use technology to make estate planning more accessible, more affordable, easier, and more importantly, to remove the barriers and educate people around why these conversations are important and how to make sure that you've protected your family using a really solid estate plan. So we are husband and wife co-founders on a mission. And really the problem is, Canadians aren't thinking about or talking about their legacy. If I asked you, when's the last time that you discussed end-of-life planning with your parents or with your siblings, your spouse, your friends, it's kind of like women and money. We don't get together over wine and talk about our salaries. We get together and talk about The Bachelorette, which I very much watched last night, and I hope you did too. And so, there's this problem that it's an uncomfortable topic to think about our own mortality. It's something we avoid like the plague. We don't want to discuss it. And that means that, unfortunately, about 57% of Canadian adults don't have a will. About 2/3 of parents with minor children don't have a will, which means that if you're watching and you're a parent, about 2/3 of you in the audience don't have a will. And even if you do have a will, we tend to stick them in a filing cabinet to gather dust instead of, keeping them up to date and treating them as a living, breathing plan that evolves as our life changes. So, why don't we have wills? Why don't we keep them up to date? Well, I mentioned a few of these barriers, the cost that's involved. It's expensive. It can be thousands of dollars for a simple will with a lawyer, not to mention paying hundreds of dollars every time you need to go back and change it. It can also be inconvenient. If you're with a newborn, you don't exactly want to leave your house. You don't want to set up appointments during work hours if you work from home. So it's not necessarily convenient to check it off your list. And let's be honest, it's complex. Before I got into this space, I really didn't know what was involved with a will. I knew that it was a document that people needed, but I didn't know what the components of it were. It seemed like a lot of legalese and complexities that I didn't understand. And so I think we often shy away from things that we don't know, and that's very much true with wills. But we had this really interesting kind of inflection point this spring when COVID hit, where we saw the conversation about and the interest in emergency planning across the board go up, because COVID really caused us to realize all those things that we had been putting off, we actually need them. And also that, the unexpected can really happen anytime. So I think it's led everyone, including me, to think more about emergency funds and life insurance and all of these other things that, if stuff hits the fan, you want to have in place. And wills were definitely a part of that. So that's the why now for why Willful is speaking on the MomFest stage, to hopefully bring this more top of mind at a time when we know more Canadians are thinking about emergency planning. So why are wills so important for parents? You'll often hear people say that they didn't get a will until they had a child, or they've been putting it off forever, but they know they need to have one because they have children. So I'm going to walk through a few of the reasons they're important for parents, and then I'll dive into, the various components of a will and what to actually think about as you're creating it. So wills are really important for parents because they ensure that your children are taken care of, both from a caregiver perspective, but also financially. So in your will, you can, plan that you're going to leave your child assets, but you can also stipulate what age they receive their inheritance, because without a will, they would get it at the age of majority, which is age 18 in Ontario. I don't know about you, but at 18, I would not have been responsible with a bunch of money. So having a will means that you can actually give it to folks, at a time that's more relevant to them, where they maybe are going to use it a bit more responsibly. If you're in a common law relationship, most people don't realize that the default laws in Ontario or most provinces don't actually account for giving any of your assets to your common law spouse. So having a will when you're a parent in a common law relationship is really important to make sure that your spouse is taken care of. A will also allows you to plan for your children's care. So, God forbid something happens and you and your spouse or you and the other parent were not around, it accounts for, a guardian who would take care of the child and make sure that they're okay until the age of majority. And then finally, it just reduces time, stress, and cost for your family. And this is also important for you if you have aging parents. I'm 35 and I have two sets of divorced parents on my husband's side and my side. And I know that I'm going to be the executor for their estates. And as a busy person with a business, an executor is a big job. And if your parents don't have a will, it's an even bigger job because you have to apply to the courts to get appointed. Things take much longer. There's more paperwork. So it's just reducing headaches for your family. And maybe you are the planner in your family like me. So maybe it's less about you getting a will and more about convincing your loved ones to get one so that the burden is reduced on you. So I'm going to dive into a bit of Wills 101 because I think there's a lot of, misconceptions and lack of knowledge around what wills even are. And I know this because I definitely felt this way prior to Willful. So the first thing is, what actually makes a will legal? So in Canada, there's maybe a misconception that you have to visit a lawyer to create a will. And while lawyers are absolutely a great option, and I'll speak to that on the next slide, you don't have to visit a lawyer to make your will. What makes a will legally valid in Canada is that it's written by you in sound mind, which is debatable for all of us right now. But, if you have Alzheimer's or you don't have the mental capacity, you unfortunately cannot create a will. And you also can't write a will for someone else and they can't write one for you. So it has to be you in sound mind. And then it has to be signed with ink on a piece of paper and witnessed by two people who also sign the will. That is what makes it legally valid. How it's created and how it's signed and witnessed doesn't have anything to do with who creates the will. So there's no law that says a will has to be created by a lawyer, although you absolutely might choose to use a lawyer to create yours. So let's walk through how someone can create a will. There's a few options, and really the option that you go with is going to depend on your budget, the complexity of your situation, and just your personal preference. And I always say, while I have an online will platform called Willful, I am not trying to pigeonhole people into using Willful. I'm trying to encourage people to get whatever's right for them. And so on the kind of cheapest end of the option or end of the spectrum, we have holograph wills. A holograph will is a handwritten will where you're literally taking pen to paper and you're writing out your preferences. It is the only type of will that doesn't have to be witnessed by anyone. So as long as you write it in your handwriting and you sign it, it's a legally valid document. Now in British Columbia, if we have any viewers from there, it's not valid for property, so real estate. So you may want to look into the nuances if you're in BC. But there's a famous case in Saskatchewan of a farmer who was crushed by his tractor, unfortunately, and he scratched a holograph will into the side of his tractor with his pocket knife, and it was upheld as legally valid in court because it was his handwriting, his signature, so it was valid. So that's the cheapest option. The next option up from there, I should point out with holograph wills, the challenge is that often if you don't have a legal background or you've never done a will before, you don't always know what to include. So for example, often people will forget to put in backup roles like backup executors or backup beneficiaries in case one passes away. So holograph wills are great, but they can often omit or leave out really important stuff just because you don't know what you don't know, and you may not know what to write on that piece of paper. A DIY will kit is kind of the level up from there. You may have seen these on Staples website or in a store like Walmart. You can even download some free forms in some provinces for wills and power of attorney forms. And again, the challenge here is that they're not as catered to your situation. They're not customizable. If you have to make, major changes, you'll have to purchase a new kit and do that. But they're very affordable, typically $30 to $40. And again, they're a great place to start, especially if you're very cost conscious. The level up from there is something like Willful. There are other online will platforms like legalwills.ca. Willful, if you go to willful.co, you can check it out. And essentially think of it like the TurboTax for estate planning. So it's still way more affordable than a lawyer. Our plans range from $99 to $249, about 4 to 5 times less than a lawyer. But it kind of is more customized than the will kit because we ask you questions about your life situation, whether you have kids, pets, spouses, etc. And your end document looks very different from someone else who has a different life situation. So it's more customizable, but it's certainly not as comprehensive as a will that you would get from a lawyer. So a lawyer is the most expensive, but they're also the most comprehensive. They can sit with you and give you legal advice. They can, write in customized clauses or put in any kind of complexity that you might have. And they're the most expensive, but they're the most comprehensive. So what actually adds complexity? When I say, not everyone might be the right fit for a platform like Willful because their situation might be complex, what does that actually mean? Well, complexity might be you're separated, but you're not divorced. In each province, there are family law rules that say that a legal spouse has a right to a share of your estate. And if you're separated but not divorced, you are still considered legally married. So your separation agreement should treat what happens or should address what happens if one of you passes away, and it should work in tandem with your will. And so that's often a situation where you may want to work with either the family lawyer or an estate lawyer or both. If we have any mompreneurs watching, if you have a business, then you may have complex wishes around it that you want to include in your will. Willful's will includes what's called a carry-on business clause, which essentially just allows your executor to sell your business, wind it down, do anything that you would do on behalf of the business. But it doesn't include any complex succession planning for your business. So you may want to speak with a lawyer about that. If you have foreign assets, so a lot of times, let's say you have a holiday home in Spain. If you do, I'm very jealous of you. You can actually create a will in Spain to cover that asset and one in Canada to cover your assets here. And those wills need to speak to each other. They need to have a clause that references the other so that, your Spanish family doesn't find it and think that that's your only will. And we don't accommodate that right now. The next one is complex trusts. So in our willful wills, we have what's called a simple testamentary trust, which is essentially just if you have a minor child and you leave them something before the age of majority or the age you've stipulated, it will be held in trust and managed by your executor, who also acts as your trustee, and they'll receive those assets when they turn the age at which you've stipulated. But there's a whole bunch of other types of trusts. Spousal trusts, for example. There's a trust for children with disabilities called a Henson Trust. We don't accommodate any of those right now, so that might be something that you have to work with a lawyer on. The second last one is you have conditional wishes. So I often get people who call and say, hey, I want to leave my child, this house, but I only want them to get it if they go to university. So it's conditional on something happening. We don't accommodate that right now. And finally, you just want legal advice. You just want to sit in front of a lawyer and have a conversation and ask them questions. That's totally a legitimate reason to want to go in and visit a lawyer instead of using an online tool. So now let's dive into what actually happens if you don't have a will. So if you don't have a will, you are what's called intestate. You have passed away intestate. So what does that mean? Well, it means that the provincial default may vary from your wishes. So a lot of times people will say to me, well, I don't need a will because when I pass away, everything's just going to go to my spouse anyways. And I always say, well, that's actually not 100% true. There's a provincial formula in each province that dictates how your assets are distributed if you pass away without a will. In Ontario, the first $200,000 go to a spouse, the next $200,000 go to a child, and it moves on down the list. So if you don't have a spouse or child, it would go to parents, siblings, aunts, uncles, etc. And that distribution often doesn't match what you would want because 100% doesn't go to your spouse if you pass away. It's split between them and the child. And while your spouses are entitled to a share of your estate, even if you pass away without a will, common law spouses aren't entitled to anything in provinces like Ontario. So it's nuanced based on your province. But in Ontario, a common law spouse would have to file a claim to get a share of the estate. There's nothing automatic. So if you're common law, really important. If you don't have a will, the court is going to appoint a guardian for your minor children instead of you being able to decide on that person. And they're also going to appoint what's called an administrator to wrap up your estate. So instead of you appointing an executor who's going to be the person who wraps everything up and puts the wishes in your will into action, the courts are going to do that instead. And it just takes much longer. It also means there's more fees involved. It can take longer for money to end up in your beneficiaries' pockets. So having a will just, sets out a clear plan. It allows you to speak when you're no longer here, and it reduces the burden on your dependents, on your family, and anybody who would be acting in the capacity of your administrator. So that being said, hopefully I've convinced you should get a will, but what are the key elements of it? A will is just this kind of nebulous thing. What's actually in a will? Well, a will is actually a pretty simple document that outlines who gets your stuff and who takes care of dependents. That's it. It's not, you don't have to have life insurance policies and investments and all of these things, your net worth statement in front of you. When you're sitting down to create your will, you need to know who you're appointing as your executor, who you're appointing as the guardian for your minor children and pets, and who you want to get your stuff. That is absolutely it. It's pretty simple. And we actually have a checklist on our website that helps you to prepare to write your will. So if you go to willful.co, you'll see an email pop up. And if you enter your email, we'll send you that checklist and you can unsubscribe at any time. But the first thing you're going to do in your will is you're going to appoint an executor. They're the people who are executing the wishes in your will. They're paying off any debts that you have. They're paying taxes because yes, the tax man's, death and taxes, two inevitabilities in life. You still have to pay taxes when you pass away. And they're going to be making lists of all of your assets. They're going to sell them. They're going to, transfer and distribute all of those assets to your beneficiaries. It's a big job. Even for a simple estate, it can take about 12 to 18 months to wrap up. And if you've been an executor, you know that firsthand. And it really does require a big level of organization and financial planning and savviness. So this can be a spouse, a family member, or a friend. You can also appoint a corporate executor, someone who does this for a living, or your executor can hire someone to help with that after the fact. So there's no, onus on your family member to do 100% of it. They have the ability to hire someone to help after the fact. And it's really important to assign backups. If your executor has passed away by the time you pass away, or they've moved to Australia and it doesn't make sense for them to do it anymore, they don't have to accept the appointment. So putting backups in place is great because then if they refuse the appointment, it just moves down the list. The next thing that you're going to do in your will after you've appointed your executor is you're going to choose your beneficiaries. These are the people or the organizations that are getting your stuff. And your stuff might be a yacht, or it might be a recipe book that your grandmother passed down. These can be things of monetary or sentimental value. And you can leave a gift in your will in two ways. The first way is leaving a specific gift. So in my will, I've left all of my clothes and shoes and jewelry to my little sister because she's the same size as me and I know she'll put them to good use. I've left, my guitar to my stepdad because he loves playing the guitar. So these are specific items that you're giving to specific people. They can also be amounts of cash, so, $5,000 to my nephew, or a cash gift to a charity. And that's something that we're very passionate about at Willful, is influencing the amount of gifts that go to charity in wills. So you can leave a dollar amount to a charity in your will, or you can leave a percentage of your estate. And these are so meaningful. I sit on the board of Save the Children Canada, and I've seen firsthand how powerful gifts in wills can be to helping these organizations achieve their goals. And only about 12% of Canadians plan to do this. So if you are creating or updating your will, this is such an easy way to leave a positive legacy. And it's tax efficient for your estate because just like when you're alive, when you leave a donation to charity, you get a tax receipt, which offsets the taxes on your estate. After you've distributed all of your specific items and specific gifts, you're going to just choose how your residue is distributed. And residue is just a fancy word for what's left after debts and taxes have been paid and specific gifts have been given out. So after my clothes and my guitar and everything, if I have a pot left of $400,000 of assets, that's the residue. And that's what you're splitting up by percentage. So that might be 50% to your one kid, 50% to the other, or it might be 20 people. You can divide it up how you'd like. And again, it's really important to assign backups here because let's say, for example, I leave stuff to my sister. I leave 10% of my estate to her and she passes away before me. I need to stipulate, well, does her share get split amongst the others? Do I want her share to go to, my brother? How do I want that to happen if someone passes away before me? And there's also something which is really important, especially if you're a nuclear family, a spouse, and children. There's something called a contingent beneficiary, which is essentially a disaster clause. What happens if you, your spouse, and your child or children all pass away at the same time? This appoints people or organizations that can receive your inheritance in that case. Again, not something fun to think about. No one wants to think about their entire family passing away. But again, your will is supposed to say, what are all the possibilities that can happen and to plan for all of them. And we really guide you through this on Willful. So even if you don't go through with completing your will, you can always go through the process and just see the questions. And we also have a really great Learn Center at willful.co/learn, where you can actually just look up articles related to anything estate planning. And again, there's zero pressure to actually use the platform. So this is probably the most important for anyone watching. How do I plan for minor children in my will? Well, if your child is over the age of majority, over the age of 18 in Ontario and most provinces, they don't need a guardian. They're going to be able to take care of themselves. And you can still leave them, funds or inheritances. And if they are, let's say 19, you can still say, I don't want them to receive it until they're 25. But if they're minor, there's this extra element of not just leaving them assets, but making sure that they're cared for in the will. So that's where a guardian comes into place. And a will allows you to appoint a guardian for their care who will manage their finances and their care until they reach the age of majority. Now, in most provinces, you're appointing them for a period of 90 days, and then the guardian has to go to the court and get formally accepted. But if you don't have a will, then the court is just, they'll accept anyone who wants to come forward and make a claim as the guardian, they'll hear them out and then they'll make a determination from there. So having it in your will is the best evidence of who you want to be the guardian. Again, this is, typically a family member or close friend. You want to think about things like not disrupting the child's life as much. So if you have a sister in Australia, maybe that isn't the best fit for them, or maybe it is. I've been to Australia and it's amazing. And you want to make sure you talk to them. I always joke with my friends that, yes, okay, I know a lot about estate planning, but I don't want to be the guardian for your kids because I don't even have a kid yet. And being an instant parent, it would be a lot of work. So you have to make sure that the guardian that you choose knows about it, they're okay with it, because again, they don't have to accept that position. In your will, you can also plan what age your children receive their inheritance. And the executor can actually use funds that are held for those children, their inheritance, for their care. So it's not that you necessarily have to leave money to the guardian. The funds would be held in trust for your child, and the executor could release some of those funds to the guardian for things like summer camp, clothes, tuition, etc. And finally, it's really good to share a care plan. What kind of upbringing do you want them to have? And again, I know this is so painful to think about, and it's the hardest part. It's where everyone gets stuck on Willful. But it's that idea of just peace of mind that in case the unthinkable happens, you've put a plan in place. Now, I know my friend Becca took about a year to do her will because her and her husband could not agree on who would be the guardian for their children. She wanted her mom, he wanted his mom, and so they sat on it for a year. And I kept saying to them, just do something, just pick someone. At least if you put it in there, you can always update it later, but at least you have someone in there who can actually be responsible for that. So I know it's a big bone of contention with couples often on who the guardian will be, but my advice is always, if you don't put it in there, your family is going to be scrambling after you pass away. So it's always good to just make a decision, and then you can always update it in the future. Can't forget about our furry friends though. So if you're a pet parent and you want to account for your pet, you can also leave money for your pet's care. You can appoint a pet guardian. And unfortunately, a big reason that pets end up in shelters is because their owners haven't planned for their care in their will. So definitely a good thing to do, especially if you're like my mom and you have 2 horses and they are very expensive. So I just want to finish off today with a little bit about updating your will. So you might want to update your will after the birth of a child, after you get married or divorced, or you purchase a large asset like a home, or even if you move provinces, because every province has different regulations. And you can do that on Willful or in general by updating it and then just executing a new version of the will. And you can do that for free on our platform. So it's a one-time fee, and then you don't have to pay for updates in future. I'm just going to go through here and quickly talk about Willful to end things off. Again, we work with estate lawyers in each province to draft all of our legal content so it's provincially relevant and up to date. You go through a series of questions like TurboTax. You get customized PDF documents that unfortunately you have to print and sign because it's the law, but we're hoping that they update that soon to allow for online signatures and storage of wills. It's mobile friendly, it's all online, so you don't have to make appointments. You don't even have to get out of your pajamas. We have a lot of brand trust. We've been featured in a lot of media outlets, so feel free to Google us and read some of the coverage as well as the reviews. We have, almost a perfect rating on Google. And we've put together a promo code for you. So if you're interested in checking out Willful, or if you have friends or family members that really need to get this in order and you've been nagging them for a while, you can send them the code MomFest20 for $20 off any Willful plan until October 31st. So you have the rest of the month to use this. Again, we have a 30-day refund policy. So if you find it's not the right fit for you, you can always get a refund. And if you really want to just chat more and hear more about Willful, you can email us at hello@willful.co, or go to willful.co/call and book a 20-minute call to talk about any questions you have. So thank you so much to the MomFest team for having us today. I'm very honored. I will be back here as an attendee in the next couple of years when I hopefully have kids. And I hope you enjoy the rest of the day and have a wonderful rest of MomFest.